Alberta's top court says the federal environmental assessment law is unconstitutional. In a 4-1 opinion released today, the justices called it a, quote, breathtaking preemption of provincial authority. Known as Bill C-69, the bill was passed in 2019, and it aimed to overhaul how resource projects get approved in this country. The Prime Minister says his government will appeal the ruling and take it to the Supreme Court.
The Impact Assessment Act delivered on an important promise we made to Canadians to reform a broken system and restore public trust in how decisions about major projects are made. The previous Conservative government gutted environmental protections, eroded public trust, and discouraged investment, and made it harder, not easier, for major projects to be built. We will be appealing this decision.
And Alberta's Minister of Energy, Sonya is here to talk about this decision. Minister, good to have you with us. I appreciate you making the time.
Well, thank you. Thank you.
My understanding from this bill and all the back and forth over it, or the law that it now became, but known as Bill C-69, was that it aimed to assess the environmental impact, but also go beyond that to see what the social impacts were, to analyze gender parity, to really make sure that this did not negatively impact climate change goals. What is so wrong with that?
Well, it's unconstitutional. It's an obliteration of the provincial government's authority, exclusive authority, constitutional authority over the development and management of our natural resources. And the court was not even subtle in saying it was an obliteration. Basically, that piece of legislation took a wrecking ball to the Constitution, wiped out two very important provisions in the Constitution, Section 109 and 92A, that Alberta has fought very hard for. So it basically rewrites Confederation. So the law itself usurped federal or provincial authority in natural resources, and it's been an exclusive authority for many, many years.
So is this about the issue of jurisdiction, or is it about your government trying to fight back against the types of analysis that the federal government wanted to conduct with this? Because I've heard both arguments, right? I know the one before the court was around jurisdiction, but the argument that the Premier and yourself have put forward in the past is that this will create a chill, that this will mean a lack of development, right? And what the federal government is arguing is that might not be the case, but more importantly, this kind of analysis needs to be done. First Nations need to be consulted to the degree as outlined in this bill. Are they wrong?
We already do that in the province, and C-69 would be not only unconstitutional and a usurpation of that authority, but it would be a duplication of it. We already do that in Alberta, and we do it very well. C-69 also added on a lot of duplication, unpredictable processes, uncertainty, time delays, and it was an onerous process, one that no proponent could have a realistic chance of getting through in a decent amount of time. But most important, it was unconstitutional. It was a power grab, and I'm absolutely certain it was intended to be a power grab, an ability to grab and take control of natural resources from Alberta. Pierre Elliott Trudeau tried to do it in the 70s to take wealth from the provinces. This piece of legislation by Justin Trudeau was to take control of natural resources to shut it down.
What evidence do you have to that effect? That's a pretty inflammatory accusation. You're assigning. I understand the argument against the constitutionality of this, but you're assigning motivation to the federal government. Do you have proof of that?
I worked on this for the last six years. I worked on it in industry, working in the oil and gas industry, and I worked on it from day one in this government. And it is no question in my mind that it was intended to be able to take authority over natural resources and to be able to manage it and to regulate it. There's many ways they could have gone.
But isn't that in the name of trying to achieve climate change targets, right?
But this is within the province's jurisdiction. Don't forget that we own the resources, and it was a condition of Confederation. We own the resources. The people in Alberta own the natural resources. People in Ontario and Saskatchewan own their natural resources. It was a term of Confederation. It was in 1982, Peter Lougheed fought very hard for this exact type of moment when the federal government tried to usurp the authority over natural resources. So it is not a question of regulation, because we do that. We do all of those things here. We have an independent arm's length life cycle regulator that takes environmental considerations into impact. We do the duty to consult with Indigenous people. We do it very well. This was an ability, this was a piece of legislation to take control from provinces.
Where's the proof, though, that it ended up doing what you say it did, that it created that chill? Because I look at statistics that show oil and gas exploration rose more than 6% last year, that oil companies in the first quarter of this year had absolutely record profits, that in fact, the province is now producing an extra 200,000 barrels of oil a day and getting it to the U.S. to supplant what the U.S. cut off from Russia. How did the Bill C-69 or the IAA stop any of that from happening?
I think it's pretty clear there has not been a new in situ greenfield project or a new mine project applied for since Bill C-69 came into effect. C-69 doesn't regulate conventional oil and gas drilling, and it doesn't regulate existing projects. What it does do is it puts a chill on any investment in new projects. It's been dubbed the No More Pipeline Act because it would be virtually impossible to get through a regulatory process.
There is a
to build
pipeline being built, though, right now.
But it was approved before Bill C-69.
But do you need, I guess my question is, what is the need for it? When you are getting 200,000 barrels extra of oil out a day, when oil companies are making record profits, when the goal is to do that, but also meet climate change targets, why do you need more pipelines?
Well, because the Constitution and this country was founded on confederation. It's a federal system where provinces have authority. We own the resources. We're best situated to manage them. This is a very large, geographically dispersed country. We're different. Each region's different. We have our own natural resources. We have our own energy production, our own way of developing electricity, and we're best suited to manage it. What Bill C-69 would have done is take a wrecking ball to all of that. It would have obliterated province's jurisdiction in this area, and that's why we fought hard for it. That's why Peter Lougheed fought hard for it, and that's why Albertans.
And I'll give you, the decision does say it does talk about the imposition on provincial jurisdiction, but it's now going to the Supreme Court, and the Supreme Court took a very interesting view, for example, of federal jurisdiction where climate change is concerned when it looked at the carbon tax, and it actually decided against the same court when it made its decision on the price on carbon, and instead decided in favor of the federal government. So are you so certain that the constitutionality argument you're putting forth will actually stand the test at the Supreme Court? Well,
the carbon price reference was a very, very different piece of legislation, and the court ruled on a very narrow grounds that the federal government had the ability to set minimum standards on carbon pricing. It wasn't about regulation of natural resources. It wasn't about ownership of natural resources. It was very narrow. But on this one, the Prime Minister, instead of appealing this decision of the Alberta Court of Appeal, should go back to the drawing board. He should sit down with provinces and say, let's find a piece of legislation that works.
Is there one, though, that would work for your government? Because while you ascribe motivation to the federal government, they certainly have accused your government of using this for political means too, right? This is like a wedge between your government and the federal government, and it's worked to your advantage among voters here.
Well, I think we go back to the drawing board. We bring industry together, we bring provinces together, we bring constitutional experts together, and we rewrite. Go back to the drawing board. And then what he should do is go back to industry and collaborate and determine how can we get more infrastructure built, because we need more infrastructure built to get energy product to market.
Why do you need more? I mean this genuinely. Please lay out the case for why you need more product, why you need more infrastructure built when there is so much product right now getting to market.
Well, because the world is going to continue to need oil and gas, even as it's transitioning to lower carbon sources, and that oil and gas is going to have to come from somewhere. Every barrel of oil or gas that gets left in the ground here in Alberta will come out somewhere else, places like Russia, Saudi Arabia, other jurisdictions that don't have the same environmental standards that we have. So we believe that the world needs energy. It should come from Alberta. Bill C-69 impedes that. It's not only unconstitutional, it makes it difficult to build these projects. It also applies to infrastructure that's needed for the transition, hydrogen facilities, hydrogen pipelines, renewable projects. So this is going to be a problematic piece of legislation, not only for oil and gas, but for the new types of energy needed for the transition.
Okay, Minister, I'm out of time. I have to leave it there. I appreciate your time very much. Sonya Savage is Alberta's Minister of Energy. We want to get a response now from the federal government. David Lametti is the Federal Minister of Justice and Attorney General. He's with us now from Ottawa. Minister, good to see you. Thank you for making the time.
It's my pleasure. Good afternoon.
I'm going to start off with a point that Minister Savage just made to me. Why, instead of appealing this, would you not go back to the drawing board and try to come up with something that is more acceptable to the province, which has just won a pretty significant decision that said your government was infringing on its jurisdiction? Why not say, okay, wait, let's take a second, let's pause, let's go back to the drawing table and see if we can come to some sort of agreement?
Well, two reasons. First of all, the process for the original bill, the Impact Assessment Act, was done through a collaborative process. Alberta didn't agree, but we worked with provinces and territories at the time, as well as Indigenous leadership groups, as well as environmental experts and people within industry. And so that was we've already have done the groundwork to develop this piece of legislation. But more importantly, for the purposes of today, we disagree strongly with the interpretation that was given by the majority of the Alberta Court of Appeal. This is not about regulating provincial. This is not about expropriating provincial resources. It's not about taking ownership of provincial resources. It's about regulating within areas of federal jurisdiction through areas that are beyond the province's ability to regulate in an area, environmental protection, which the Supreme Court has held on a number of occasions, most importantly in the carbon pricing reference, but previously as well, is an area of shared jurisdiction. So we're not impeding on jurisdiction, we're not obliterating jurisdiction. All of that rhetoric is a bit over the top. I would point you to the dissenting decision, which is compelling, which is very well argued, and which we feel more accurately represents the actual state of constitutional affairs in Canada.
I understand why you would point me to the dissenting opinion, but it's my job to ask you about the majority opinion. And in that opinion, it does say the federal government does not have the constitutional right to appropriate the birthright and economic future of the citizens of a province. I take your point around environmental shared jurisdiction. But this is also about natural resources, which traditionally are provincial jurisdiction. Do you regret being so heavy-handed in imposing this bill on the will of provinces in light of this decision? And does it not necessitate a second look?
We're not appropriating anything. We're regulating. And there's a very strong distinction in Canadian law, Canadian jurisprudence, the distinction between regulation and taking ownership or expropriation. We're regulating for the benefit of the environment in areas of federal jurisdiction, in a process that is rigorous and collaborative and supported by a number of people on the ground, not the least important of which are Indigenous peoples. And so they need to have a seat at the table, and we need, as a federal government, to be able to impose standards on projects when there's spillover into other provinces, when there is impact on certain species and other environmental elements that do fall within federal jurisdiction as well. And so we're not exceeding the boundaries of our jurisdiction. We've narrowly and carefully tailored this act to stay within federal jurisdiction. The provinces also have their jurisdiction, and nothing we do here has appropriated resources from the provinces. That is simply untrue.
Not appropriated, but what about the point the minister was making, for example, and I believe you could hear the interview, around the lack of new pitches being made, new applications being made for infrastructure? She's accusing your government of essentially putting this bill into law or making this bill a law so that you could have more jurisdiction over natural resources and thereby stop the development of them.
That interpretation, I think, is simply unfounded and untrue.
Are there new projects going ahead, though, under this piece of legislation? Have there been a lot of new projects? She's saying there aren't.
Well, they need to pass muster under environmental standards. The environmental standards are appropriate. We don't shy away from that. We made a commitment to Canadians to fix a broken process to protect the environment. We're doing that. Previous processes were flawed in the sense that they didn't take Indigenous peoples and the environment adequately into account, and we're doing that. There's also been an economic climate, as certainly you know and Canadians know, with the pandemic and other shifts in the world economy that would have been a factor. But our goal here is to protect the environment and to allow projects to go forward that will work in harmony with the environment and will work in harmony with Indigenous peoples and other Canadians, sometimes in other provinces, other than the province in which the project is located. The environment doesn't know jurisdictional borders. It doesn't know provincial borders. And so the federal government has a strong role here in protecting the environment. The Supreme Court said that in the carbon pricing case. And we think that the decision doesn't square well with the kinds of principles that, first of all, existed before the carbon pricing case, but also after.
It's not just Alberta, though, making a case against this, right? I've spoken to a number of ministers back when this was going through the House of Commons from Quebec, for example, who thought it was replicative, that it was replicating work that province already did. And we know that Ontario and Saskatchewan were also against the bill becoming law because of the same reasons. It's the jurisdictional issue at hand. Are you saying no, completely no to the idea of any sort of rewrite, any sort of amendment, even something that would lay out, for example, an appeal process, which the court highlighted doesn't exist? Well,
as a government, we're always open to making anything we've done better. But with respect to this process, the Alberta government has never demonstrated any good faith willingness to work on this particular piece of legislation. They've just opposed it from the start. And so we have this piece of relatively new legislation. It is beginning, it's beginning its life, I suppose, as a law, if you want to put it that way. And we're defending it in court. We'll continue to monitor it over time, as will Indigenous groups, as will provinces, as will territories and other industry stakeholders. But it is, we feel. And there will, look, it's an area of shared jurisdiction. So there will be necessarily areas where there is overlap. We know that. The Supreme Court has said that. The provinces know that too. But what we are doing is making sure that in areas of federal jurisdiction, certain kinds of analyses are done. And to say that every province has taken those areas of those areas adequately into account, those areas of federal jurisdiction, I think would be an exaggeration on their part. So we're here to ensure that the environment is protected.
Pardon me, the problem is it seems that the court disagrees with what you are qualifying as federal jurisdiction. Just one question before I'm out of time, Minister, and that is sort of around, as you highlighted, the changing nature of the economy. We do have a situation right now with Russia's war on Ukraine where, for example, the U.S. has banned the importation of Russian oil. They first went to Venezuela and Saudi Arabia to get more oil, to supplant that supply before coming to Canada. And the supply Canada can send there is limited as well, because there is a cap on the means through which that oil can get to the United States. Isn't that a problem? Is that, because of laws like this one and the desire, as the province accuses your government of not wanting to see new pipelines built, the no pipelines bill, as they call it? And is there any regret there on your government's part that we could, in fact, be helping out in this awful geopolitical situation to a greater degree, but we aren't?
Look, you've said it. It is a very awful situation. It's tragic, and it is something that sadly was in the control of one human being, Vladimir Putin, and the Western world is reacting in support of Ukraine and getting them resources is one way to do it. We still produce a great deal of oil and gas. There were record there are record profits very recently in that industry, and we as a government have been open to assessing new projects. We did approve the Trans Mountain expansion. it was before this
Before
piece of
this.
legislation came in. However, the process that we imposed on ourselves, and also that the Federal Court of Appeal imposed on us, brought us to a standard that is very similar to what's contained in the Act. So it is something that is possible, but it's good projects that are going to move forward. And we do need to protect the environment. We all should be fighting climate change instead of fighting each other in court. There is a transition that simply has to happen. It has to happen justly, and frankly, the kind of rhetoric that we just heard from Minister Savage isn't always helpful in fighting climate change. That's the priority here.
Okay, Minister, I'm out of time. I have to leave it there. Thank you very much for your time. I appreciate it.
Thank you.
David Lametti is the Federal Minister of Justice and Attorney General. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.